Your case is ready for trial. What happens if the defense lawyer is not in court at the time your case is called to go pick a jury? Can the judge go ahead and dismiss the defense's arguments and now you get an automatic win? You want to know the answer? Come join me for a moment as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So let's say you brought a lawsuit against your doctor for medical malpractice, claiming that he violated the basic standards of medical care, causing you significant harm and injury. And now the doctor denied doing anything wrong or causing you any harm or injury. Okay, they say, we'll see you at trial. Fine. So now 2 years down the road, your case finally comes up for trial. Your attorney has prepared you for trial. He's prepared you for his questions and for cross-examination. Your attorney has prepared all of your experts. He's gotten all of his exhibits lined up. He's gotten all of your medical records into court, waiting to start your trial. Okay, so now on a specific day, your attorney has told you that they're going in to pick a jury. Terrific. Now, how does that work? It means that all the attorneys who are assigned that day to go ahead and pick a jury, they file into a big courtroom, and now you have a trial assignment judge go through case by case to decide what's going to happen. It's called a calendar call. And on that calendar call, both sides have to appear and answer whether they're ready or not ready. And now, let's say your attorney answers that he's present, he's ready. And he turns around, he says, where's the defense attorney? Your lawyer says, I don't know, Judge. Now the judge has an option. The judge can do a number of things. Many judges will turn around and say, fine, we're going to mark this second call. Now what does that mean? It means since not everybody is there at that moment, we're going to go ahead and give the attorney a little bit of time to get into court, now to go ahead and show up and answer on behalf of his client. That's a courtesy, right? So not everybody is there. Maybe they're stuck in traffic. Maybe there's some other explanation. Maybe they have another case they have to attend to immediately. And some judges call the calendar right on the dot at 9:30. And if you're not there, it's going to be a big problem. Other judges sometimes give the attorneys a little bit of time, and they'll start the calendar call at 9:45 a.m. or 10 a.m. Now, here's what happens during second call. So now, maybe 15 minutes later, half an hour later, the clerk goes through and calls all those cases that have been marked second call. What happens, though, if your attorney now stands up on the second call and says, Your Honor, plaintiff is ready? And again, the defense attorney is nowhere to be found. What can the judge do in that instance? Well, there are a couple things the judge could do. One thing the judge could do is he could strike the defendant's answer. Now, what is that? That's a very significant thing. When the defense answers the allegations in your lawsuit, they have to either admit them or deny them. So, in all likelihood, they have denied that they did anything wrong. They have denied that anything they did caused or contributed to your injury. And they deny that your injuries are significant or permanent. That's typical by these defendants, these people who are being sued, the doctors and the hospital staff, in any medical malpractice case. Now, what happens if the judge decides to strike their answer? Well, it's as if they never answered the allegations. And in that instance, what that really means for you is that you get an automatic win. Automatic win. That's really a default. So imagine the Mets are playing the Yankees, right? And now they're playing at Citi Field. And for whatever reason, let's say the bus breaks down and the Yankees don't show up. The Mets are standing around waiting to go ahead and play, and all the fans are standing around waiting, trying to figure out when the game is getting started. And guess what? Finally, there's an announcement made saying that the Yankees aren't coming. Well, you know what? The Mets get an automatic win by default. They don't actually play the game because the Yankees didn't show up. It's the same exact thing here. If the defense attorney fails to show up, it is possible for the judge to strike their answer as if they never appeared in the lawsuit to begin. And what that means for you is that you get an automatic win by default. Is that the end of the case? Actually, it's not. What happens now is you have to have a trial on damages. Because if you get an automatic win on liability, you no longer have to try your case to determine whether the doctor violated the basic standards of medical care. You don't have to have a trial for a jury to determine whether the doctor's carelessness was a cause of your injury. You now get to go to trial and put on your medical experts, put on your treating doctors, so that now the jury can evaluate the value of your injuries. Now they will have to assign a value to the pain and the suffering that you endured because of the doctor's carelessness. And then they'll have to assign other values, other monetary amounts to the different elements of damages you've claimed in this case, whether it's lost wages or medical expenses or some other type of lost income or damages that you have claimed. So the second part of the trial, after you've gotten an automatic win where the defense doesn't show up, now will be only to assess how much money you are to receive as a result of the doctor's carelessness. Now, what happens if the defense lawyer finally shows up after he's an hour late? Can he go into the judge and say, "Judge, could you do me a favor? Could you not give me a default? Could we go ahead and actually try this case?" That is a possibility. But in order for him to do that, he has to approach his adversary, the plaintiff's attorney, your lawyer. And the two of them have to go in together to try and speak to the judge. Not every judge will allow the attorneys at that point to come in and talk to him. He may say, "No, listen, if you want to reverse what I just did, you have to make a formal written request called a motion, and now you have to put forth in writing the reasons and an explanation why you're so late, and the reasons why I should not have stricken your answer and given your opponent a default win." And now the plaintiff's attorney will have to go ahead and oppose that. And many weeks later, those papers will now come up for argument in front of the judge, and he'll have to reconsider this particular argument. Will he agree with the defense lawyer and say, "Listen, there's no real harm here. Let's go ahead and put this case back on the calendar," a simple administrative matter by checking off a couple of boxes on the computer and now having it come back on a couple of weeks later for jury selection? Or he may say, "Listen, I'm now going to put this back on the trial calendar, but guess what? I'm putting it at the bottom of the pile, and now you have to sit and wait your turn until it gets all the way to the top again." That could be 6 months, it could be 9 months, it could be a year. And that's a possibility. So there are many different options the judge has when the defense lawyer fails to show up on the calendar call and answer on behalf of his client that he's ready to go. So why do I share this quick information with you? I share it with you just to give you an inside look at what can happen and has happened from time to time when an attorney fails to show up in court when your case is on the trial calendar ready to go and he doesn't answer the calendar call. You know, I do recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but are thinking about bringing a case and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.